He has a day off, 2 days off.
Where's the link? Where's the link? Where's the link?
Are you coming to observe, or you have cases here this morning? Hey, good morning.
44 man.
4:37.
We have an MGM.
They're gonna be in the conference room,
Oh, okay.
because we're about to do a big hearing.
Great.
I mean, big meeting is gonna last a while.
The people inside there. They're doing it in there.
What's open?
The confirming.
Oh, okay.
Simsford. I mean, I know he's got no history, and we can go down the time if that's accountability we didn't, but it's got to be deferred. I mean, just because they're going to take care of that shit.
Yeah, let me see, because he's from,
Gotta think it's how much your Gloria's back there.
Who's talking?
Gloria, she'd be the one.
Is it Rashawn? Yeah. Oh, I don't think it's wrong. Oh, okay. Oh, God, I hope not. So I thought you Cause I got another case that's gotta go to Miguel's court too. Okay, you're fine. I'm sorry. Yes. What else you want to say?
Is Caitlin in here? Caitlin?
It's like deja vu from yesterday. Right there. You didn't forget about it.
Are we ready on the change of venue?
Yes.
Yes? State?
We have a couple people in the bathroom.
Okay.
All rise.
Okay. Everybody may be seated. Thank you very much.
Yeah, and I have my pen.
Okay. Where's the where's the state's response to the
Did you ever finish that trial?
I'm sorry?
You already finished that trial?
She pled midway. I'll tell you something later. Motion? No, there's a state's motion. State's motion response to the defendant's response to rent collector, defendant's response to state's motion report. There's going to be a state's response with affidavits. Yes. So, I don't know why they realize that they just money for waters. So, I mean, that's not true. But for me, they don't disappear.
Yeah, that's right.
Okay.
There's some duplicates, but
Okay.
Jason, get the restarted. There's no password to it. You should have restarted. Okay. And if it times out, you just have to keep restarting it. They won't get the password. 2-story.
So we're going to go on a hearing. We're going to go on a hearing and extend the hearing and change the rating. Okay. One country union. You already. Okay. Okay. With the council.
Can we?
Get him an extra chair.
Judge, where would you suggest?
Yeah, that's fine. That's fine. Somewhere, it's an evidentiary hearing, so you should be up here with you. Okay. Let me know as soon as that's up and running. It has a delay somehow. Every trial we have.
The green screen, once the green screen comes up, then shortly after that, it'll come up.
Up, down, left.
No, they're for the computer.
Change the sleep time on that. If it goes to sleep. I have to start working through. Just FYI.
Thank you.
It turned off?
No, actually, I think it's on, it's just, it's on the phone screen for the power, so. But, what we're talking about, how do you, you're the one that needs to see it.
Yeah, that's good, that's good.
Is that right?
That's good. Just tell me when you're ready. Okay, 2024 CR 2701, State of Texas versus James Brennand. Will the Lords please make their announcements?
Darrell Harris with the state.
Amar Scott.
Patrick Valentine, Jason Goss, Jay Norton, and Nico Wood for James Brenner.
Okay, I'll note that this case was re-indicted under this case number I just called. It was previously indicted under 2022 CR 11443. And we're here for a motion for change of venue. And also, someone have a
Just
phone?
step up at the back, please. Just take the whole back, just step up at the back.
Okay, did you hear everything I said?
Yes.
Okay, now, this case was previously indicted under case number 2022 CR 11443. And we're here for a motion for change of venue and the state's response to defendant's motion for change of venue. Those motions were filed under the old case number. However, on March the 4th of 2024, the state filed a motion to adopt all motions in this case to the new case number. Is everyone in agreement that the motion for change of venue and the state's response are adopted into the motion, into this new case number?
Yes, Your Honor.
Okay, so obviously it's the defendant's motion for change of venue. Is the state ready?
State is ready.
Okay, is the defense ready?
Defense is ready.
Okay, so it's your burden, defense, so if you can proceed, please.
Thank you, Judge. In the way of a brief opening, I just want to give the court an idea of what we plan to do today. The state has been very congenial in working with us on determining the admissibility of certain exhibits, so we believe this hearing will be more streamlined than it could have been, so we do appreciate that. Your Honor, I'm going to reiterate the standard for change of venue under 3103, even though I know you're very familiar with this standard because you've dealt with it in your own practice. But there's, of course, two different grounds for change of venue, and the first is that there exists in the county where prosecution is commenced so great a prejudice against him, the defendant, that he cannot obtain a fair and impartial trial. And then there's the second ground that there exists a dangerous combination against him, the defendant, instigated by influential persons by reason of which he cannot expect a fair trial. And the reason that I'm putting both of those out there at first is, Your Honor, those are two separate viable grounds for change of venue. But they're not distinct in that they are to be considered in isolation. And in this case, I think represents an example of why that is not so. Because in this case, we do have pervasive and inflammatory pretrial
Could you
policy.
just speak up? I didn't quite hear that. In this case, we have.
In this case, we do have pervasive and inflammatory pretrial publicity. And in this case, we do have a combination of influential persons who are pushing a certain narrative that has defined that pretrial publicity to the disadvantage of the defendant. And this dangerous combination, that language is a little archaic, Your Honor, and it could mean different things in different circumstances. But the way we're using it here is that they are not dangerous in the sense that they present some sort of physical danger to anybody. They are dangerous in the sense that they are endangering the defendant's right to be able to achieve a fair trial and an impartial jury. And so when we say dangerous combinations, that's what we mean. Your Honor does not need to find that there's any nefarious action going on the part of any of the individuals we talk about today. Just that the things they have said, the narratives that they have framed and pushed into the public have resulted in a disadvantage to the defendant and his right to obtain a fair trial. Your Honor, we are going to enter into evidence a binder full of, I believe it's some 139, or at this point maybe above 140 individual news stories in this case. And I don't expect Your Honor to read every word of those stories. The reason we put them all in a binder is to show the volume and the pervasiveness
Okay, then the defendant's exhibit number 1 is admitted into evidence.
General like that here.
Excuse me. Thank you.
So, I think what that binder of news story shows, and by the way, every one of those contains links to either a news article or to a video story about this case, this defendant, this complainant. And I would represent to the court, and I know Your Honor's been involved in high-profile cases where change of venue has been considered and warranted. But I would represent that this case has received more consistent and persistent media coverage than really any story in recent history, and that includes various capital cases or cases involving murders and celebrity-involved cases. This has it fit a narrative of the time that was going on back in 2022, and that narrative took off in the public's consciousness, and the media propelled that narrative, as is their right and really their obligation to do in public reporting. But it does have an effect on our potential jury pool. And that public narrative, it's not just that the media coverage is pervasive, but it's also the nature of the public narrative. And that narrative presumed that James Brennand had no possible justification for exercising deadly force on that night. It presumed that Eric Cantu was the victim of some senseless police violence or brutality. And here we get to the influential persons, because Chief McManus, I believe, is the primary person responsible for crafting that public narrative, for initiating it. When he said there is no doubt in anyone's mind that this shooting was not justified. He said later, the defendant's conduct was not justified criminally or administratively. And I would submit to the court that there is no more essentially prejudicial statement that could be made under the circumstances of this case. And it was made by one of the highest ranking law enforcement authorities in this community. In fact, if Chief McManus were an attorney, he would be subject to professional discipline for making such statements publicly. District Attorney Joe Gonzalez then seized on that narrative and continued it. We are not saying he said anything nearly as inflammatory as what Chief McManus said, but he propelled the narrative. He inflamed it. He pushed more of that narrative into the public consciousness with his comments. And so to those ends, Your Honor, we are going to be offering into evidence this time Defendant's Exhibit 2, and that's a press release from the District Attorney's Office, released October 12th, 2022. Defendant's Exhibit 3 is another press release released shortly after the indictment was obtained, December 1st, 2022. We are also offering Defendant's Exhibit 4, which is a press conference that Joe Gonzalez gave on December 1st, 2022. We are offering Defendant's Exhibit 5, which contained video clips of Chief McManus stating the things that I just quoted him saying, as well as other things. We are also offering Defendant's Exhibit 6, which is a press conference held by Attorney Ben Crump, who is the civil attorney for Eric Cantu and his family, in which Mr. Crump makes inflammatory public statements and furthers the prejudicial narrative in this case. Let's start with this.
the state has no objection to defenses 2 through 6. Would bring the court's attention. We have previously discussed also admitting another exhibit, which would be the DA press conference from October the 7th, which they are not. The state likely, just give me where we likely will continue to admit it when we get to our case.
Okay, that's fine. So defendants exhibit 2 through 6, you have no objections?
No objection.
So defendants exhibit 2 through 6 are admitted into evidence.
Okay, Judge, and we would also seek to admit defendants exhibit 7. This is I believe I would characterize it as a real justice PAC news release and, I guess, press release and fundraiser on behalf of Joe Gonzalez. Council's previously viewed this, but it is marked as defendants exhibit 7. We would offer that at this time.
The state would object to the admission of exhibit 7. It is a news release from a private entity, not an elected official, not anyone that would be an influential group. It does not contain any new or original statements from the district attorney's press conferences or SAPDs or any influential person. It's simply regurgitation. So we would object as to relevance, and it would be completely.
Okay, is that the one that
Yes,
we
sir.
talked about? Okay, I'm going to go ahead and admit it. So defendants exhibit number 7 is admitted into evidence.
And finally, Your Honor, Mr. Goss is going to present some arguments and publish some clips from the exhibits that you just admitted. I have Mr. Goss's presentation marked as defendants 8, and I would seek to introduce that in the record, but not as evidence.
Okay, so basically, so he can play it, correct?
Yes, sir.
The
Just a
presentation.
copy of the copy
Okay.
for the record. And Your Honor, with that, we would rest our evidence and present argument at the appropriate time.
Okay, and state?
And, Your Honor,
Well, Mr. Garza is working on that. Just for the record, the state is going to introduce State's Exhibit 1. These first few exhibits, Your Honor, are the affidavits that were attached to the state's response to the defendant's motion to change venue. State's Exhibit 1 is the affidavit from Tamara Strouch, S-T-R-A-U-C-H. Is it okay if I just go through all of them and then, is that okay, Your Honor, if you go through and talk about it? Yeah. Okay. And then State's Exhibit 2 is the controversy affidavit from Oscar Salinas. State's Exhibit 3 is the controversy affidavit from Stephen Spear. State's Exhibit 4 is the controversy affidavit from Elena Altus. And then, Your Honor, State's Exhibit 6, I've grouped these by date, and State's Exhibit 6.
You've grouped them out, I'm sorry?
I'm sorry, State's Exhibit 6, these are the 18 citizen affidavits that were got from that were done in the jury room. And these State's Exhibit 6 are all the ones that were done on November the 7th, 2023. State's Exhibit 7 are the controverting affidavits. They are the 23 citizen affidavits from November the 8th of 2023. And then State's Exhibit 8 is one controverting affidavit from a citizen of Bear County on November the 14th of 2023. And then State's Exhibit 9 are 27 citizen affidavits from November the 15th of 2023. And then, those are all the affidavits. And then also, Your Honor, State's Exhibit 10. This is a portion of the San Antonio Police Department General Manual. I would like to admit, specifically speaking to SAP policy and use of force, use of deadly force.
Okay, so, Your Honor, with regards to, well, the only thing we have an objection to is State's Exhibit 10. I don't think that has any relevance to the change of venue standards. Whether it's relevant at trial or not, that's an issue for another day, but SAP's policy on use of force is relevant to either of the problems that Your Honor is considering today.
Your Honor, I'm sorry.
Go ahead.
What we're saying is that it is relevant because of Chief McManus's statement. In his statement, he makes some things about the justification. I think Mr. Valentine already pointed out that that's one of the things that we want to highlight. And what we want to put it in context to is this Chief McManus's statements are in context to what the SAP policy guidelines with use of force are. We think that it's contextual and relevant to that.
Okay, I'm going to overrule your objection. So, what about through states 1 through 10? Any objections from the defense?
Well, we objected to 10. Your Honor's overruled that. So we don't have any objections to any of the other exhibits which Ms. Scott has just introduced.
Okay, then states exhibit 1 through 9 are admitted without objection, and states exhibit 10 is admitted over objection. So they're all admitted.
Yeah, that's fine. And then we are going to have one more exhibit, but we're working on getting that to you. That will be State's Exhibit 11, and that is going to be DA Joe Gonzalez's press conference that he gave on October the 7th of 2022. He gave 2 press conference statements. Defense has already admitted 1, and that's from December the 1st of 2022. We also want to admit the one that he did on October the 7th of 2022. Sorry.
For the courts, whereas it will be entered on a flash drive, which I'm just now downloading from the evidence repository. Counsel was served with it last night.
Could you please your voice up?
Counsel was served with it, well, I uploaded it to the evidence portal last night, and I believe parties are aware of it as one of the initial press conference DA Gonzalez gave on this matter October 7th. We thought it was relevant, cited in their motion. Don't mean to give unfair surprise, but we do think the court should consider it in its decision on this matter.
Judge, that's fine. I'm familiar with the video he's referring to, and when it's tendered to the court, we'll have no objections.
Okay, then I'll wait until you tender them and
As
so
soon
get
as
them.
we get a vote on it.
States 11?
States 11.
Okay, so any objection to states 11?
No objection.
So states 11 is admitted into evidence.
also ask the court to take judicial notice of the Texas Secretary of State's website, where it lists as of calendar year 2022, there were 1.2 million registered voters in Bexar County. The state cited that in its motion responding to defendants' effective change of motion, and I believe the contents of that figure will be germane as an argument. And attendant to that, that any potential juror in Bexar County comes from that list of 1.2 million voters, which would be impaneled to hear this case, be it in this county or any county.
Okay.
Okay, then the court will take judicial notice that there's 1.2 million registered voters as of when?
The end of the calendar year 2022.
Okay, we'll do. Okay, State, anything else on evidence?
Your Honor, the state would call
Ho- ho-
Jorge Terrazas.
Hold on, let me see. Hold on. Does the defense have any witnesses?
No, Judge.
Okay. Go ahead.
Your Honor, the state would call Jorge Terrazas Rivera. He is the manager of the activity going down based on the district court. We had anticipated their case would go longer, so it would take us a moment to get him here, Your Honor.
That's fine. Go ahead.
While we're waiting, may I have the stomach?
Sure. Jorge. Terrazas. Here. I don't know my eyes off the shit.
On the record, he's on his way now. Just from downstairs.
Okay, and just, we're not on the record right now, but you all are going to present most of this evidence today, right? I mean, I want to see whatever you want me to rely upon. I don't want to have to go back there and then on my own be reviewing it, because I'm going to hear arguments from you today. Is that accurate?
That is our intent.
Okay, that's fine.
I've clipped the videos that we've entered in a way that highlights the worst stuff.
Okay,
And then I think the record the court has for the record that there's tons of articles and all this.
sure. No, I just anticipated more witnesses, but
We did too before everybody agreed.
that's good. The more agreement, the better. Let's just give Mr. Terrazas a couple of minutes. And if you could raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth to help you God?
I do.
Okay, you may lower your hand and speak clearly into the microphone.
Yes, sir, would you introduce yourself to the court, please?
Yes, sir. Sorry, I'm a little bit out of breath. My name is Jorge Tarastarona. I am an administrative system coordinator for the Central Jury Room. And sorry, I ran out here.
Why don't you take a minute to get your breath. That's right, don't worry. We have time.
Sure.
So just catch your breath. That way we can get clear testimony. That's not a big deal.
You good?
Yes, sir.
Can you state your position again, please, sir?
Yes, sir. My position is an administrative service coordinator for the Central Jury Room of Bear County.
Okay, and from that title, what are your day-to-day duties?
I'm in charge and point of contact for providing providing jury panels to the courts, and also for creating and supplying lists for the courts and calling those out.
Mr. Harris, can you make sure your mic is on and speak into the mic, please, so I can hear you better?
Yes, sir. Your Honor, I think that's the first time anyone's ever told me to speak up.
Okay.
All right, and approximately how many jurors, citizens of Bear County, actually come in for jury service on an average day?
So it depends on the day of the week. Generally on Monday and Tuesday, between 500 to 600 people up here for jury service. Now on Wednesdays and Thursdays, it's a little bit lower. Wednesdays being roughly about 350 to 400, and Thursdays being about 290 to 350.
So by my quick math, that's approximately 1,900 citizens a week, Monday through Thursday, come in for jury service.
Yes, sir.
And these are all different people. Each one of those days, people from Monday don't come back on Tuesday.
Exactly, it's a very rare occurrence, but there are different people every single day.
Right? And are you generally aware of where those 1,900 Bear County citizens, how are they picked for jury service?
There's summonses sent out to them depending on if they're registered to vote. That's one way that we get the information, send out a summons, or if they do have a driver's license or state ID.
Okay. And would it be fair to say, in your experience, then that each of those 1,900 citizens of Bear County are all registered voters out of the state of Texas?
Yes, they're qualified.
Okay. Did my staff reach out to you and your office in December of 2023 to ask if we could talk to some of those jurors?
Yes, we did.
And do you recall that we showed up on 3 different occasions over a 2-week span in December?
I did.
Okay. Actually, my apologies, late November before Thanksgiving.
Yes, sir.
All right. And as I believe, and this was as you were dismissing jurors that had not been used, correct?
Yes, sir.
And then you introduced me, and I talked to them and said, you don't have to if you're willing to give me a minute of time.
Yes, sir.
Okay? And each and every one of those people were registered voters eligible for jury duty in any court in Bear County.
They were. They had been qualified and by a district judge before that day.
And we were there to take affidavits from them about a case. Remember that?
Yes, sir.
All right. How long have you been in your position sending jury panels to courts in Bear County?
I have worked for the Central Jury Room for approximately 3.5 years. However, my current position has been in that position for about 2.5 years.
All right. And just the way it works, can a court, if it has a case that may have garnered publicity, can a court bring larger than normal amounts of jurors to a panel for jury selection?
The number of jurors is determined by the court, so whatever number of jurors that the court requests, we will provide as long as they are.
And have you also seen jury selection in the trial happen in the central jury room itself? We did that, we coded for space.
Yes, I have.
But it would allow in non-COVID conditions for an expanded panel beyond the norm, wouldn't it?
It would.
I have no further questions, Your Honor. I pass the witness.
Defense.
Yes, sir. Some questions for you, sir.
Yes.
Were you present and did you observe Mr. Harris interview and talk with the various people who ended up ultimately giving an affidavit?
Yes, I was present, and yes.
And for example, let's go to November the 14th, which is one of the days that this apparently occurred. And that's a Monday, so there's approximately 600 potential jurors downstairs, is that right?
Yes, sir.
And on that day, the state got one affidavit out of 600 potential eligible voters.
I do not know the exact number of affidavits. I just know Mondays are also a very busy day, so not many people were left at the very end.
Okay, so just by nature of what is occurring, this is not at all a representative sample of 600 people on November the 14th.
It would be, I don't know exactly.
Okay, but I'll ask it a different way. If 600 people got sent to courtrooms to be put on panels, to be interviewed by civil and or criminal potential jurors, all those people are not part of a sample that has anything to do with their knowledge about this particular case, because they're being used in another way.
No, not everybody was interviewed or eligible for interview.
So it's not a real sample of, on that day, 600 potential jurors.
No.
And I could go through each day, but each day, it was Monday, Tuesday, 2 weeks in a row. Same thing would apply. This is not a representative sample of Bexar County eligible voters.
Not for all that here.
And were you present? Did anybody tell the state, yes, I am aware? Or do you recall the question that he asked? How did he bring it up? How did he interview the people?
I do not recall the exact question. I just recall him speaking about saying that he was garnering affidavits to speak whether or not they knew about this particular case.
And if they knew about the case, did he take an affidavit from them?
I believe so. I did not see any of the affidavits.
Okay. So if there are no affidavits that say, yes, I'm aware of Mr. Brennand's case, then we can assume that no one who knew about it gave an affidavit, because there are none.
I do not know.
Okay. So again, that would not, if you're only taking people who say, I don't know, again, that's not a relative sample numerically with the other potential jurors. You're just cherry picking and selecting who you want to talk to.
So once again, it was just the people that were left at the very end of the day. That was everybody sent a report completely at random. So the people that were left at the very end were completely at random, and there were varying numbers of people left at the very end.
Right, but again, in the totality of what you deal with, that's a very small sample of people.
It would be a small number of the people that.
And if the state did not obtain any affidavits that says, yes, I am aware of this incident or of this officer's name, in fairness, you don't recall how he asked. You don't know if he said Officer Brennand, the guy that allegedly shot somebody in a parking lot of McDonald's. Any kind of facts were elicited, or do you remember anything about the question at all?
I do not remember anything about the question at all, besides him just saying there was a change of venue and he was garnering affidavits. Whether people knew about the case or they don't.
Okay. And for purposes of my question, just assume that there are no affidavits that say, I am aware of this situation. However it was described to them, however they were told about it, there are none that reflect that. For example, on November 14th, one person said, I am unaware of this situation. Does that comport with your memory? Do you, on that Monday, again, it's busy and it's a long time ago, so. Do you know if Mr. Harris only talked to one person on that day?
We opened the floor, and we did not have anything to do with the process of asking
Sure.
for updates afterwards. So I do not know the exact number
Okay.
of the people that Mr. Harris spoke to.
Or how he spoke to him or any of that kind of
I do
thing?
not.
Thank you, sir.
Anything else?
Just brief follow-up. We were learning as we went. The first day, it was people were being released out in the hallway in front of the cafeteria.
Objection
Yes,
to
sir.
leading, Your Honor, and that's not a question. It's the same. Prosecutor's testifying.
I'll overrule you right now. Just try and open an question.
Okay. You remember that one day?
Yes, I do.
And if you recall, was I just seeking volunteers?
Yes.
So jurors could stay if they wanted, or they could leave.
Yes.
Did we, on subsequent days, did we move it from that hallway? Where did we move it to?
To the center room.
Did my tone, from your knowledge, and you introduced me, if I recall,
Yes.
and then thereafter, you drifted out?
Yes, sir.
Was anybody held hostage?
No, sir.
Were the jurors free to leave on their own?
That they weren't have been released from jury service.
Did you ever hear me ask if anyone had seen publicity, please leave? Did you ever hear me ask that?
No.
Did you see that one juror, while standing in line to sign an affidavit, actually Googled the case?
I don't have any knowledge of that.
So you didn't see that?
No.
And that juror, and you didn't see that juror still continue and fill out the affidavit, which is tendered to the court. Did you see that?
Objection to leading, and he already is unaware, he can't possibly answer a question that he's unaware of.
That's a state, okay?
No further questions, sir.
But I think bottom line, in fairness to your testimony to the court of honor, you don't remember how or what Mr. Harris asked.
Not specifically, no, sir.
Okay. That's it.
No further questions.
Okay, you're excused, sir. Thank you very much.
Sir.
Okay, state, go on the next witness.
Your Honor, the state request.
Okay.
Judge, we did have a brief rebuttal that I'd just like to talk about with the court. These documents, which I'll label as
He has that demonstrative as E.
how do you say it? Yes, sir. 9 and 10.
Nine.
If I just may approach the court.
Okay.
So 9 and 10, it's pretty simple, but it's just a representative of how many hits you get on a Google search if you search James Brennand, and how many hits you get on a Google search if you search Eric Cantu. And the reason that we're offering it is not, obviously we don't know what all those different things are, but just to give the court an understanding or an idea that when you put those things in, it pulls up for Brennand, it pulls up tens of thousands, and for Eric Cantu, it pulls up hundreds of thousands. The articles and the local articles and the things that we think are most important, we have reprinted there. But I'm just offering it just for the benefit of the court to say, I mean, it's something you could do right now on your phone if you wanted to.
Yes.
And get the same results.
To show it to the state, please.
I've given it to them, and they've let me know that they haven't, I think that they haven't objection to it, so.
And so you're offering it to show the cumulative number of
Yeah.
articles that you highlighted on the upper left-hand corner, correct?
Yes.
Okay.
Yes. And the search terms I used are also reflected on the document.
Your Honor, we, with objection in two parts. Number one, it is cumulative to what's already admitted with Defense Exhibit 1, and 2, relevance. While it's simply a numerical listing of clicks on a certain term, be it the defendant Brennand or Eric Cantu, there's no way to distinguish from the totals if it's one person doing it repeatedly every day for a month, if it's the same folk, that it's anytime anything occurs in any other venue, it calls, well, that looks like something that happened in Bear County with the same viewer. So it is redundant, it's cumulative. We would object on those grounds.
And Your Honor, if I may just briefly respond, I understand the court. I'm not asking the court to give this like great weight. It's just I believe that the court can give it the weight that it's in. Just to say, look, there's just a lot of stuff. We didn't go and print out every single thing because we would have just had binders filling up this courtroom. But it's just to give the court an idea that like it's even past local. There's stuff all over about. Particularly James Brennand, which was one of the search terms used. It's not as common of a name as perhaps Eric Cantu, and we just wanted the court to see that in its entirety and give the weight that it's entitled to, which is of course yes. We don't know that each one of those dealt with that.
And that would be my point, Your Honor. If it's not local, then it's not relevant because only local to Bear County would be in this jury.
Well, I mean, there's no jury here. It's just to me, and I'll note what you stated that, for all I know, there's favorable hits in there about Mr. Brennand. Number one, for all I know, one individual clipped James Brennand 1,000 times. So your objections go to the weight, not to the admissibility. So I will admit it and take into consideration the weight I'm going to give it. Okay?
Yes, Your Honor. And that's as far as rebuttal. That's all the rebuttal we would have. We would just go to our.
Okay, so you're done with your evidence?
Yes, sir.
And the state is done with your evidence, correct?
Yes, Your Honor. Yes, sir.
Okay, you're not calling any witnesses either side?
No, Your Honor.
No, Your Honor. I think, so our affidavits, our original affidavits are with the motion. If the court would like us or feels that we should offer those affidavits into evidence, I don't think that it needs to be, but.
No, what I'll do is I'll take judicial notice of the affidavits, the controverting affidavits that you all filed with your motion, because that is required in the law, so.
Yes, Your Honor. Yes, in answer to the question, the witnesses would have gone to getting in the evidence that we have in front of you, but really it's the weight of the evidence that we argue that should be considered, under the change of venue standard.
Okay, then, and as far as the taking judicial notice of controverting affidavits filed with the defense, does the state have any objection to that?
No, Your Honor.
Okay, so I'll take judicial notice of the controverting affidavits filed by the defense. Okay, so go ahead, defense.
Would you like argument now?
Yes.
Yes, sir. So, as Mr. Valentine talked about before, would you mind if I approach this?
No, go ahead, please.
So, as Mr. Valentine talked about before, what we're talking about in the case law is we're talking about inflammatory publicity, and the test is whether outside influences affecting the community's climate of opinion as to a defendant are inherently suspect. And so, what I want to do is go through some of the things that are in these items of evidence, and I guess some specific clips that go to explaining why we are arguing that this is that the publicity has been inflammatory. And in particular, Mr. Brennand can't help any of this stuff, but he is entitled to a fair trial. And when you have a situation like this, and as Patrick said, this is one of the highest publicity cases that have occurred in a long time. And so when we go through these things, it's watching and seeing what people like Chief McManus, people like Joe Gonzalez, who are important members of this community, are saying about our particular client, about this man who has the right to a fair trial, and then how the media coverage is kind of swirling around that and repeating those claims. So, as far as the dangerous combination, we talked about it, likely to influence in some manner the way in which the trial proceeds. And so that's, this is kind of the some manner aspect of it. So we talked about the Google results. James Brennand, you get 13,400 results. And these are articles, and so you can kind of see the front page, but we've taken about 100 and something of those articles. But when you do Eric Cantu, you get 700 San Antonio, spelled the way that the complainant's name is spelled. I mean, that's 738,000 results. This is Chief McManus shortly after. This is him discussing Mr. Brennand's case with CNN, but this was also reprinted and repeated in KSAT.
But to answer your question, the video was horrific. There's no question in anybody's mind looking at that video that the shooting is not justified. And
so that is the central issue in this case. We are not disputing whatsoever that Officer Brennand shot Eric Cantu, but the issue in this case is whether or not it is justified. What I am concerned about is a juror who is sitting there, it goes through the trial, and in the back of their mind goes, yeah, but his own chief said it wasn't justified. So these defense attorneys are arguing that it is, but his own chief doesn't think so. And they don't necessarily even remember that they saw something like this, but this was everywhere. Chief McManus was everywhere giving interviews saying James Brennand is not justified.
Why did the department decide to bring up these charges?
why?
Yes.
Because, well, starting off with the shooting itself, it was unjustified, both administratively and criminally. So since there was a criminal component to this, that's why we investigated that criminal offense.
And I kind of want to address, I can't remember the exhibit number, but they put in the departmental policy aspect of it to say that they're putting this into context, that he's talking about his policies. But it's clear here that what he is saying is not a violation of departmental policy. It is a violation both administratively and criminal. And so Chief McManus has injected himself in his opinion into the public conscious of San Antonio, and he is somebody who would be an influential person, especially on this issue. I mean, he's basically testifying as an expert against Officer Brennand, or acting as one with the news media and making those comments that are go to the heart of our defense. Now, that's the other thing too, is that they, at this time that all of this is happening, they still didn't have all the facts. And so they are quickly coming out and saying these things, whereas in years later, we have the benefit of some of the other things that have happened in this case that they don't. But however, this has just remained, and it's remained in the public conscious that his own chief believes that it's not justified, which we think couldn't be furthest from the truth. So, this is Chief McManus. This is one of the articles that's included. The article is titled "Eric Cantu's Family Seeking Justice for Teen Shot by SAPD Officer." I'm sorry, I know that was fast. But reading it, McManus says, "You don't know for certain that it's the same vehicle. You don't know for certain it's the same driver who evaded it the day before. The driver was going in the opposite direction, away from the officer. There's no way I could look at that, or anyone could look at it and try to justify what happened." The first part of this is completely 100% wrong. It's almost everyone is in agreement. The state and the defense are in agreement that it is the same vehicle and that it was the same driver as who evaded from Officer Brennand the night before. But what he's done is he's gone into the media and he has stated things that are factually untrue, and reporting later on had to correct the fact that he did know those things. And the problem with this is that McManus knew that the night it happened. because they interviewed the passenger of the car that night, and she said, he is the same driver. We did evade the day before. So he knew that this was an untrue statement, or should have known, because his officers had interviewed. So either he knew it was not true and decided to say it, or he didn't know that if it was true or not and said it anyway. And that is, either way, it's putting a false narrative, not just a bad narrative, but a false narrative into the public. And again, he just keeps, with anybody who will listen, he keeps saying that not just him, but anyone. So anyone, there's no one that could justify what happened, which goes directly to our defense. This is, so as the court is probably aware, and this is also in the evidence, the announcement was made in a press release from Crump's law firm that the shooting was wholly unjustified. So now we have Mr. Trump saying that it's wholly unjustified. And then here is some snippets from a press conference that happened up on the steps of our courthouse with the family of Mr. Cantu.
Speak publicly because they were just focused on their son. They knew everybody was talking about this case across America. The kid who was shot in the McDonald's parking lot eating a cheeseburger. But they understood that we were going to get to this day. The most important thing right now was him making it through a day. They wake up every morning with the same prayer. Let my son make it through the day.
I'd like to see former officer Brennand behind bars right now. It's not safe with him out there.
And you know, Victoria reminded me of something. You watched the video when her son said, "I've been shot." What was his response, Victoria?
I want my mom. He was calling for mom. I just want mom. That was the most painful thing to watch.
Yeah. And Eric, what did the cop say when he said, "I've been shot"? You have to come to the mic.
The officer, former officer, not officer, said, "Yes, you have, because I shot you."
That is the response, the callous response of this police officer.
No humanity behind his voice. Dropped him off at the University Hospital, said, told his sergeant, "Oh, he'll be fine. He's going to be okay." Not knowing what he did.
I mean, so to answer your question, what charges would you want for an officer who heard your son say, "I've been shot," and he jokingly replies, after he shot him multiple times, "I know, I shot you"? Any other questions? I mean, he used the most the most confrontational. I mean, he went and opened the door, putting not only his life in danger, but the occupants' life in danger. Who teaches you to do that? To go open a door of somebody who obviously you suspect is a problem. And why? Why, you ask? Because he profiled this young Hispanic teenager. He profiled him, Lulac. There's no question about it. You will hear from my co-counsel, Attorney Greenke, what the district attorney told the parents about what the officer said from his own words. It was a Hispanic kid with a bowl-shaped haircut. That's it. That's why we're here. That's why he shot 10 times. 10 times. He shot 5 times, and then he said, shots fired, and then he shot 5 more times. My God.
So, Mr. Crump, what this is demonstrating to the court is that there was an intent in Mr. Brennand's case, and this is happening in the late autumn of 2022, right after this is going on. But there was an intent, an inflammatory intent, And so, and look, this isn't about, oh, it's the state's fault. Well, the state's not responsible for Mr. Trump. That's not the issue that we're considering. We're considering taking in everything together. He has a First Amendment right to come out and do that. Even though a lot of the things he said turned out to be false. But he has a First Amendment right to come out and do that. But along with the First Amendment right, then we go to our Sixth Amendment right, to due process. We go to the 14th Amendment right, to due process in a jury trial in this case. So, I want to point out that, Mr. Crump is having them describe the situation as Officer Brennand being cold and callous. And at the time that Officer Brennand was speaking to Mr. Cantu, he was giving him life-saving resuscitation. He was trying to save his life, which he ended up contributing to the fact that Mr. Cantu is still here. But none of that stuff is mentioned, so they're selectively putting stuff in the media that Mr. Brennand is cold and that he's callous. And then when they go to the racial profiling, that's why it's important to go back to the fact that now we all know that Mr. Cantu was the person evading from Mr. Brennand the night before. And so Mr. Brennand was correct in all those assessments that he made that this is the same guy. That's uncontroverted by the state because their own witnesses have said it, who were witnessed the night before and they were witnessed there. So the fact that Mr. Crump would do this on our courthouse steps, what he's trying to do for his own purposes is he wants to inflame this community. He wants to inflame the passions of our community, which, fine. But if you do that, then we have to give this man a fair trial somewhere else because you have come in and you have done those things. And the same kind of thing with these statements that McManus is making and the DA Gonzalez is making. So these are some just representative articles that, we have articles about this is the failure of one police officer, these are statements made by Chief William McManus. There are experts, the media has had experts that are talking about, this one is an expert, Craig Miller, who testified in the Amber Geiger case in Dallas, but they're pontificating on facts in this case, and they're pontificating on it, and then articles are coming out with these expert opinions that have gone into, again, that will work to inflame the potential jury pool, and it works against our ability to defend Mr. Brennand the way that Mr. Brennand is entitled to have his defense. We've included this as in our exhibits, but I just wanted to address the fact that the headline. This is before the November election because it's a campaign fundraiser for DA Gonzalez, who was reelected in November 2022. But DA Joe Gonzalez is making sure this guilty cop is prosecuted and charged. And then as you go through, they're describing this case. They're talking about how it's basically in their interest to get this word out that that DA Gonzalez is prosecuting a guilty cop. So he's been, as far as this goes, he's already been tried and convicted for them, for their purposes, for this Real Justice PAC purposes, who are trying to elect reform DAs who prosecute police officers. So I want to talk specifically about December 1st. So this is a press conference that happened, as the court noted, there has been a new indictment. This was the press conference that Ms. DA Gonzalez gave after the first one. And he made a few statements that we want to talk about. The grand jury indicted December 1st, and that's an article discussing that. And then Mr. Gonzalez said, right after the indictment, we certainly are going to be seeking what we believe to be an appropriate punishment. And right now, to me, the maximum punishment appears to be appropriate. The maximum punishment in this case is life in prison. So what DA Gonzalez has said on the day of indictment was that James Brennand should spend the rest of his life in prison, and that's what's appropriate. There is no reason for DA Gonzalez to make a statement like that. There's none, except that if it helps, I guess, further a goal that he has to represent to the community that he is hard or tough on police officers. But a life sentence, telling them at that press conference that a life sentence is appropriate, is inappropriate. for that, like, it's, so with DA Gonzalez, there cannot be it's just, it's not justified. I mean, I think as a district attorney, as a prosecutor who is under those kind of rules, there's no point in saying that he has to have, that he needs a life sentence in prison. And by saying it in a press conference and in public, when you show the court that he said it in a press conference, and then the papers are picking it up, and then they're reprinting what he's saying in the papers, and it's just continuing to build this publicity of basically, he's a monster, let's all go get him. And that's not fair for him to have a jury trial in a jurisdiction where that's happened to him, and it's not his fault. I wanted to discuss this re-indictment because McManus, this is an article from Texas Public Radio. McManus said his department did not come to the conclusion that attempted murder charges fit, but that the district attorney's office had the last word on the decision. And we believe that that is true. I mean, the DA's office decides what to charge. This is from an interview with Eric Cantu's mother with Good Morning America. So this was a national interview that happened, but also appeared, Good Morning America appears locally on Channel 5. It's KSAT is one of the places that carry it.
We'd like to see the charges raised to attempted murder, 2 counts, and other charges lead to any officers that were involved in the brutality during the arrest.
So when the grand jury indicted him, after McManus said attempted murder is not something that they believe, she goes on Good Morning America. The DA's office does indict for attempted murder, and the San Antonio News article from December 1st also talks about the fact that Joe Gonzalez told reporters that his office will seek the maximum punishment, life in prison, against the former officer. So that was just DA Gonzalez reading that attempted murder count. So you have the police chief saying, I don't think that attempted murder is right. The complainant's mother goes on the Good Morning America and says she wants an attempted murder charge. Then he gets indicted for attempted murder on the first, which they publicize. And as I told the court, the facts the undisputed facts are that James Brennand tried to give life resuscitating treatment after he shot, which, as the court knows, cast doubt on any kind of attempted murder charge. But March 6, 2024, yesterday, we have the newest article, DA drops attempted murder charge against ex-SAPD officer who shot Eric Cantu. The issue with this here is that in combination, it seems, a charge went out of attempted murder. And the court can, I know the court's not going to go back and look, but I'll just represent to the court that if you look at the articles that were going on locally at the time, the attempted murder charge was the one that ran. Like, the attempted murder charge was the headline thing. Like, DA charges police officer with attempted murder. It doesn't make much sense. As practitioners, we understand that the attempted murder charge is A, harder to prove, and B, a second-degree felony. They already had 2 first-degree felonies, which was the aggravated assault by a public servant. But it does make sense if you're doing this charge in order to inflame the public, in order to have that be the headline, attempted murder, and then quietly dropping it in the new indictment, because now the new indictment, count 3, is not attempted murder. But what has happened is that our jury pool in Bexar County has been inundated with attempted murder, attempted murder, attempted murder, and then they sweep it out so they don't have to prove it. But what that leaves Officer Brennand with, Mr. Brennand with, is that now the jury's in a situation, the potential jurors there, if they saw attempted murder, which the DAs went and indicted, and now they don't see it anymore, if that's still in their mind, that there was this intent to kill and that it's got the name murder in the charge, that can also affect his ability to have a fair trial here. And that was something that, however it happened, I showed the court the timeline. Police don't think attempted murder is right. Mother goes on and says, I want an attempted murder charge. DA indicts an attempted murder charge. DA quietly dismisses attempted murder. But they put now attempted murder out into the public. So in addition to all the other publicity and everything else, we are in a situation where, and it goes back to the end, that's, to wrap up what I'm saying, is that we are in a situation that we don't have to do it in Bear County. It's obviously up to the court, but it's not something that must be done. We can ensure, the court is in a position that the court can ensure that there is not that taint, and that the court can ensure that we can have a jury panel that has not been inundated with all of these articles and all of these things, and doesn't know that there was an attempted murder charge that's been later dismissed and dropped. We are in a position, the court's in a position that we can do that. And to go where the state wants, what that would allow is for them to release press releases, passively allow Mr. Crump to inflame the jury panel. Let the chief of police say that there is nobody on this earth who could ever believe that there's a possible justification for what Officer Brennand did, and use that kind of language, both administratively and criminally. All of these things happen, and then they can go and publicize their indictments for attempted murder, and do all of those things, and then have the jury pool in the same place where they've been able to do all of that. Most cases, I would agree, don't necessarily. I mean, you're going to be able to get a jury pool, but in a jury somehow. But this case, it's been so pervasive. The media has covered him once a month at least for the last 2 years, and in the beginning, all of those media articles and everything else has tons of engagement, has more engagement than anything else they got on their sites. Every time they do a Brennand story, that's what the public is engaging with. And that's why they have so many of them. And so all we're asking is for the court to say, instead of hoping that we can get a good jury, let's just guarantee that we can by going to a county that's close, that's convenient for all the parties, but that's far enough away that hasn't been exposed to all of these things. And that's why we're asking for the change of
Thank you, counsel. State.
Your Honor, may it please the court, I'd like to speak in general to the three parts of the defense's argument. Number one, focusing in on the press releases that started with Chief McManus on or about October 11th, and the comments made about no one doesn't abide with our training and experience. And for that, we simply offer that the chief is speaking in his capacity as the leader of that organization, and the policy and training that the officers in the organization are held to. It's just a factual statement that went out in a press conference in answer to a question. Similar thing to the district attorney press conference, not going out promoting, exacerbating, or responding to a question asked for the request. It is the epitome of the head of the largest law enforcement agency in the county and the elected DA for the county reacting to issues that are of interest to the public. Context-wise, when SAPD, pursuant to the city's policy, released that video October the 5th, yes, it went from 0 to 100 across the nation immediately. It would be, in some measure, irresponsible for those two officials not to explain or something to that effect to the public. Two, they filed a change of venue. Now, by law and statute, that is a two-part process. The two primary means to discern whether publicity is pervasive is a hearing on the motion to change venue here, and then the voir dire process, which happens at trial. Right now, we are 15 months after the December 1st press conference. The state collected and offered its contravening affidavits to eligible jurors in this county at 12 months afterwards. And we had one lone juror indicate they had awareness of Officer Brennand, his case, his charges, and that was solely because she stood in line, Googled it while she was waiting to sign the sworn affidavits. Each and every one of the 68 eligible voters were given the opportunity to fill in anything they added, that they had known, they had seen it, etc. And the simple question, do you know of any reason why Mr. Brennand could not get a fair trial in Bexar County? 68 citizens. Along with that, we offer similar statements, and then counsel hones in on the statements made by the officials in responding to public questions. This county has dealt with other high profile, high visibility, media savvy cases. The killing of an SAPD detective in 2021 was tried in this county. The killing of a Bexar County Sheriff's deputy in, I believe, 2015. That was tried in this county. That's why the law for venue has a two-part prong. Pre-trial publicity, which is assessed in a hearing, as we're doing now, and then the jury selection process of trial. The case law in terms of the elected official, a DA, making inflammatory statements. I refer the court and counsel to Bunton v. State of Texas, 482 Southwest 3rd 58. This case was a capital murder retrial for punishment sentencing. The state changed its future danger requirement, and this convicted capital murderer had to be retried. At that time, the district attorney in Harris County made a statement to the Houston Chronicle stating the appellant would be released to mandatory parole if he only receives a life sentence and not death sentence. All of that went into a hearing and trial for a change of venue because of tainting the jury pool. And then that retrial still occurred in Harris County. It did not fit the standard. I can think of no statement by an elected official that will be more on point than the appeal to a death sentence in a capital murder trial. And oh, by the way, I forgot to mention he killed a police officer. Then in that context, the issue is not the totality of the publicity that is out there. It is not the number of news stories. It's not the number of clicks. It's not the number of articles, most of which are just regurgitations of what came out in the first month, but the effect that it would have on the public such that Mr. Brennand could not get a fair trial, a fair and impartial trial. And I believe, well, counsel, we all know what our media accessibility and access is today in present times. But we haven't been able to see, it hasn't shown that it would affect the potential jurors of Bexar County. And to it, the converse, because it's all nationwide, all of it would affect jurors in any other county. But absent some effect that citizens of Bexar County can't handle it, and there is none. Even if there were, it would best be determined with jury selection and whether or not we could not see a proper jury. And the court itself has tools to remedy that. As we just discussed with Mr. State's witness, Mr.
Terrazas.
Thank you. My staff would say, name slipped my mind often. We can ask for an extended panel. We can conduct jury selection in a larger space and facility. I'm not saying that the defendant's appeal may not be found true at a later date in jury selection, but I'm simply saying it's premature today. Ultimately, Your Honor, the state is aware of everything the defense brings up. We are not trying to contribute to it or add to it, but we don't believe there has been a sufficient basis for the court to conclude that Mr. Brennand has been prejudiced as we stand here right now, and we would argue that you should deny the defendant's motion and we proceed to scheduling of trial.
Your Honor, just a brief rebuttal.
Yes.
First, I think that one of the reasons we do the venue transfer, we try to get that decided, is because if we think that it's going to go that way, it wastes so much resources for us to try to pick a jury and then find out then that, okay, yeah, so this panel's not going to work, and we just keep doing that. That's why we're asking for the decision to be made so that we can, so everybody can know, plans can be made, and we can be, like I said, guaranteed. You can guarantee that he would be able to get a fair trial. Just to talk about the nationwide. So I agree, there has been nationwide coverage. It has been all over the place. However, the dangerous combination of influential people is what is important, I think, in the court's consideration of that, because any other county, McManus is not their chief of police. Any other county, Joe Gonzalez is not their district attorney. And so the influential people, the reason that they have more influence here is because Mr. Gonzalez was elected by the people of Fair County. So you have to assume that that's the person they believe should be making these kind of decisions or in that spot. And Chief McManus, although not elected, has been here for a long time, and the public is used to seeing him and hearing from him. And so they are more influential, and they are influential in Bexar County. They are not influential in any other county. So that's because it's not just this press conference or this article or this thing. It is the pervasivity of it, and so that's why we're asking. As I said, we can guarantee he can get a fair trial somewhere else, and we're just asking for that guarantee rather than let's hope and pray that it does happen the way that it should.
So, rebuttal, Your Honor. Well, just
Well, the burden's on defense, though, but I'll let you rebut the
okay,
rebuttal.
just
Okay.
so one thing, counsel, note that had not been raised, and just specifically, we typically phrased it as if we can get to it right now, saves time and efficiency. Court of Criminal Appeals addressed that specifically in Gonzalez 222 Southwest 3rd 446, saying, having the hearing, then holding a ruling in advance until a certain amount of voir dire is conducted, then granted denied, based on how the panel members actually requested. This procedure has the advantage of permitting the trial court to grant motions with actual merit and give the court insight into the jury pool, community attitudes, and opinions towards the accused in the case. Simply saying that's the insight the court needs to make an informed decision, not the generalities that we've had here. And it's not so much a short thing skipping a step, it is an essential step.
In a brief rebuttal, I think the court knows what I mean. You can make the decision. If you think that it is, you can make the decision to go. You don't have to do that step because that could require a lot of wasted resources. I think that they've been granted before in that way, and it can be granted now. That's the only point I was trying to make. Yeah, oh yeah, that's true. And also, Mr. Johnson reminded me the closer we get to trial, the publicity's ramp back up again and all those other things. But I'll rest on it.
Okay, well, in light of the fact that you all agreed to most of the evidence, like I said earlier, I thought there were more live witnesses. I need to review the evidence that you all offered and introduced before I make a decision. So let me just, I'll give you all the timeline as quickly as I can so I can review some of this evidence, okay? So, if there's anything else from the state, no?
No, Your Honor.
From the defense? Okay, then that closes the record for today, and I'll get back to you as quickly as I can, okay? Thank you very much. I will. How do you want to work it with the exhibits if I need to look at all this stuff? How do we deal with the exhibits because they're in your custody? Yes. Okay.
I don't mind, just keep them and then once you review them and make a decision, I'll
Yeah, why don't you hold it for after lunch, maybe at 1:30? You're still going to be around, right?
Yes.
Okay, just maybe you bring them to me, and we'll take it from there. I don't know if we're going to have still more docket this afternoon or not. I'm not too sure. Yeah, we're going to this afternoon. Okay? And can you give me copies of that Gonzalez case and that Button case when we get a chance?
I was actually going to give her copies too, so she can.
Okay, that's fine. Just give them to her, and I'll look at them for her, okay? I'm going to go grab one, Brennand for now, and
The night mags were.
the night mags? Is there night mags?
Yes, some of them are, and then some of them are county court cases. The two last ones are night mags.
The what?
My Uncle Bill was a trial lawyer for a long time. And anytime he'd go prepare for trial and think it was going to last all day or 2 days, and they dismissed it or something happened, he'd go, "This is the day the Lord has given back to me, and I'm not going back to work." So I was thinking maybe